Spread the fire, fam. Welcome back to SMWX. If you're new around here, my name's Dr. Sizwe Mpofu-Walsh, and on this channel, the Sizwe Mpofu-Walsh Xperience, we explore South African politics through interviews and analysis. In today's episode, I speak to renowned broadcaster and political analyst Eusebius McKaiser, and we switch things up. It's not so much an interview as a conversation on South Africa's constitution. Now, in the opening weeks of 2022, this debate has gained new attention because of an article written by Minister Lindiwe Sisulu, but we wanted to move away from the immediate political conversation and try and have a deeper debate/conversation about whether the Constitution is the appropriate and most optimal text to move South Africa forward into a new just future, and to what extent the Constitution actually plays a causal role in some of the crises that we face as a country. And so we have differing views on this, but we thought it would be important to role model a debate between two friends who come from a generous position towards one another, but also share some disagreements about the Constitution in its current state. Hope you enjoyed this. Unfortunately, clever me forgot to press record on Zoom, so we don't have the video recording of this, but we have the full audio of our conversation, and you can also listen to that on Eusebius's podcast on In the Ring, which is available on all podcast platforms. Enjoy. Ayeye.
I feel welcome to your platform. I always have FOMO when I see other people being invited, and the huge justified interest in your work. You know, I'm a big fan of your work, and we've got mutual respect, disagreements from a position of mutual respect that we'll tease out today as well. And welcome onto my platform also. And we can get straight into it. For me, there are two broad questions that we need to engage. You and I see it differently, but the framing alone should be helpful to my listeners and to your viewers. The two questions for me that are really interesting to have in public and that shouldn't be the exclusive realm of lawyers or academics and scholars in the academy, yourself included. In the public space, I think there are two interesting questions. One question is the Constitution the right vision for the country? A separate question is, would changing the constitutional text make a difference to the justice project? And since our lunch where we agreed that we would do this, I've been mulling over those two questions, and they are grammatically easy questions to formulate, but if you take them seriously, there's complexity that happens very quickly. And then on top of that, we are in a news cycle where this week, you know, the next Chief Justice is to be interviewed. And so our philosophical conversation about the vision of the Constitution, whether the Constitution can be tinkered with to get us to a more just South Africa, is also important. It's hopefully the kinds of issues that will emerge also when the Judicial Service Commission interviews the candidates and engage them on their jurisprudential convictions and not just playing politics as a body. But I think our starting point should be to dip into those two questions. And maybe I can kick us off, because I think although both of us critique the Constitution, I think I like our Constitution a bit more than you do. And I think
you can open the batting.
A natural dialectic is for the person that wants to make a thesis in Hegelian terms, to start off and to put a positive argument on the table to be discussed. You know, Sizwe, I found it difficult to answer the question whether the vision in the Constitution for South Africa, a nascent democratic South Africa at the time that it was written and adopted finally in 96, is the right vision. Because I realized nerdishly that before you and I can debate whether that vision is deficient, we better be clear on what that vision is, and we may or may not even agree whether A, there's a vision, and B, if we do agree there's a vision, we may not even agree descriptively on what the vision is in the Constitution. So we're getting ahead of ourselves to even debate whether it's in the right ideal South Africa that is depicted in the Constitution. So I thought to myself, keep it simple, Eusebius, and also don't overthink it. But I just couldn't succeed, and I hope you did a better job in your homework, because I thought to myself, if you go to the constitutional text, which you've done on this platform before, brilliantly, you've revisited and engaged this question also in your book, The New Apartheid. But there's no section in the Constitution that does what you would do in political theory, in ideal theory, or in utopianism, where you say, let me paint a picture of what kind of South Africa we wish to live in, that is the ideal South Africa. So although constitutional scholars and those of us who studied constitutional law as part of undergraduate law studies were told there's a constitutional vision, I realize now that I'm not quite sure what that vision is, because you've got the preamble, you've got the basic foundational values, freedom, dignity, equality, and then the most we can do is to infer a vision based on the rest of the constitutional text and the history of constitutional case law. So I'm no longer confident that I can give a depiction of the constitutional vision for our country to put on the table for us to then debate in whatever way we can. But here's the best that I can do. I think the vision, to the extent that one can infer one from a little bit of the preamble, the foundational values, particularly the Bill of Rights and case law, is that we imagine a South Africa to be a just South Africa if there is substantive equality in particular, and that substantive equality should be cashed out in terms of whether every single citizen has got their inherent self-worth affirmed, and whether they have the freedom to live a life that they had genuinely chose in terms of their autonomy as an individual. Hence the three foundational values: dignity, freedom, and equality. The detail and minutiae we can get into, I'll pause after this for you to come in. But I think the best we can do to tease out a vision of a substantively equal citizenry is that justice is to be understood, and the vision of a just South Africa through the prism of the constitutional text is to be understood as a society in which every single citizen ideally enjoys substantive equality. What substantive equality amounts to piggybacks on other part of the constitutional text and what we can glean from what the jurist had said in case law.
Yeah, absolutely. And I think firstly, just on this subject of the questions, what we've done before this is really think quite deeply about which questions really need an answer in the public debate at the moment, and narrowing the focus. And I think part of the problem that we have both found in the Sisulu fracas is that a host of things were being blurred. The rule of law, constitutional jurisprudence, the constitutional text, the legal order were all basically objects of critique at different times when it suited different parties. But you know, the first stage in trying to deepen this debate is framing the questions and clarifying them.
Yeah.
And so we're looking here at the constitutional text. There are other questions, or we might go a little wider than that. But first, asking this question about: does it present the vision for South Africa that is the end point, and that leaves only the details to be filled in? I think that's the view that I'm really interested in. There's this assumption on the part of jurists, scholars, lawyers, and observers that we've got the place that we're heading to right.
Yeah.
And all we need to do now is execute. And I think it's important for us to take a step back and say, well, do we?
Yes.
And not, and I just want to distance myself from so many different critics, because as soon as you take a critical eye on the Constitution, you're thrown in with a rag bag of reprobates. I don't look at this from the perspective that the Constitution is evil and all of it needs to be abolished tomorrow and it's a white supremacist document, etc. I'm interested in asking that question because if we probe at that question, we may find new ways to conceptualize South Africa that break us out of the stagnated the stagnant place that we're in. So just by way of preamble, if you'll excuse the pun, to come onto your points, I think it's really interesting, firstly, to say that it's actually hard to discern a vision, and how we might go about discerning that vision is actually not as easy as we think it is. And I hadn't thought of that before. My approach was simply to go to the text, look at the preamble, look at the founding provisions, and then to a lesser but important extent, the Bill of Rights. And those three opening sections seem to me to be the heart of the kind of visioning process. And the rest of the Constitution, from chapters 3 all the way to 14, seem to me to be about setting up the state that is then going to achieve this vision. And so one way to do it, I suppose, is to look beyond just the text and look at how jurists have interpreted the text in various important judgments. Another way to look at it is to look at how the Constitution itself has become almost a shorthand when politicians want to talk about the vision for our society, or anyone wants to talk about the vision for our society. But I do think your preliminary point is interesting, to the extent that I think very few people know what the Constitution actually says. And in writing my book and reading closely, I didn't realize how long the Constitution is. I once asked someone to print it out for me quickly, and they came back with this thick document, and I was like, oh, sorry, I should probably give you some money for that. So it's a really long document, and it seems to me that one of the ways of looking at that vision is to look at the preamble, the founding provisions, and the Bill of Rights, and then to see whether the kind of society that is envisioned, or at least articulated in those early opening sections which undergird the rest of the Constitution, whether those are indeed sufficient to take us from our apartheid and colonial past into a new and more just future. And that's the methodology that I think is appropriate, but there may be many others.
No, I think that's fair. I guess what I would ask you, logically following from that, is, before we get into the critical engagement about whether it's the right vision, how would you depict what that vision is?
I would go to the text, and I would say, firstly, that it's very vague in the Constitution, and we encounter a series of bywords and euphemisms in order to start with that vision. So it seems to me that the Constitution is saying we come from a bad place, and this Constitution now marks a crucial departure point from that place, and is in some ways the opposite of the bad place that we came from. The bad place is never named, and then I would agree with you. It seems that there are three key values which underpin all the remaining rights and opportunities that are afforded to the citizens as a result of those values, and that's human dignity, equality, and freedom. And it seems to me that you can almost read the Constitution through the prism of those three key values, for lack of a better term. So bad place, we're going to a new place, and in order to get there, everything has to be based on dignity, equality, and freedom.
I think that's right. I was thinking, though, that notwithstanding overlapping consensus between you and me about aspects of the constitutional text and constitutionalism that haven't succeeded in getting us to a just society. I think the easiest part of this dialogue is going to be agreeing on the gap between the Constitution and empirical reality. Anyone who thinks the Constitution has delivered justice is living in cloud cuckoo land or in Sandton. And that's just, for me, a complete non-starter. Where you and I will disagree later is the extent to which the Constitution is an important part of the diagnosis of the problem. But to come back to this first question, and I really hope that our viewers and listeners are enjoying not rushing to the question of, is the Constitution a problem? and can changing it be part of the solution in a meaningful way? The question of the vision is a really interesting one. I think there's more to be said, and feel free to push back. There's more to be said appreciatively about the constitutional text than I think you give it credit for. Firstly, you are right about the vagueness problem. But I think good legal interpretation scholars agree necessarily that it is intrinsic to language that there will always be a vagueness problem. There wouldn't be a need for legal adjudication if ordinary language sufficed to understand all rights in all sources of law, not just the Constitution as a text, but also other statutes. If we take, for example, a matter involving a relative of yours today, the Criminal Procedure Act is subject to a day-long back and forth between the state and lawyers for the former President Jacob Zuma. Why? Because it's not
I'm not
obvious.
related to Advocate Breitenbach. So.
Touché. And why is that the case? Because statutes are written in natural language. Natural language is both lucid, but is also subject to interpretation. So that's a quasi-defense on the vagueness issue. And I agree there's vagueness. I just don't think it's unique to us. I don't even think it's unique to the Constitution. I think it is intrinsic in all sources of law, and that's how legal adjudication arises as a discipline in the first place. But I concede it. I just think you are harsh about what to do with that fact. For example, as a philosophy student, one of the vagueness elements that always fascinated me is dignity. You find in case law, and I challenge lawyers who hate us non-lawyers engaging these issues to respond to what I'm about to say and to prove me to be wrong with citation of case law. If you were to do a deep dive into the appearance of those three foundational values definitionally in our case law, Sizwe, you will find that there's no self-standing definition of dignity that doesn't reference either freedom or equality. But if you then go and you do a deep dive into the appearance definitionally of the concept of equality and substantive equality in particular in our case law, it constantly refers back to dignity. And so you've got this kind of circularity where the foundational values are constantly defined in terms of one another. I don't think it's a problem that is too bad, because I think some of these concepts are a little bit like pornography. You know it when you see it, even if you can't come up with the perfect one-sentence definition. But there is a genuine vagueness problem, which is why philosophers might spend some time saying, I want to spend the next 10 years to really try and understand dignity in a more perspicuous way than you might find in case law. And sometimes in philosophy of law, you can do it. I had a good friend who's now a fantastic advocate in Joburg, Advocate McConaughey, who spent his DPhil at Oxford working on the question of dignity in law and loving animals. In his particular case, one aspect of that was to further ask, besides making sense of dignity, can our jurisprudence on dignity extend to animals that are not human persons? So there is a vagueness problem there for sure. But let me fast forward a little bit, because I'm waffling, but hopefully not bad waffling. There are aspects of the Constitution that is a clearer guide for a better South Africa than your quick summation. Take our socioeconomic rights. Take third-generation green rights. It is unkind to not appreciate just how progressive it was in the 90s, not just vis-a-vis the continent, but the entire globe, for us to entrench justiciable or legally enforceable, to use non-pretentious language, legally enforceable socioeconomic rights against the state. Incredible. The same with the right to a safe environment. Rights that now come into play when we debate such questions as, can the state even imagine enacting compulsory vaccination? Can a workplace do so? On one side of the debate, part of what you might draw on are the third generation rights that the founders of the Constitution probably didn't even imagine might come into play in 2021 in a debate about vaccines. There is a level of complexity that is fascinating. When you go down to the specific subsections and individual elements of those socioeconomic rights, there's pressure on the state to prove that it has, from a budgetary point of view, done everything it can to, quote unquote, progressively realize access to water, access to housing, access to education, which is why the TSC case could be won, which is why Subramani happened in the first place, which is why Grootboom happened. And I'm going to pause there for you to respond, but I think the exposition is enough, not enough to say the Constitution has delivered justice. You and I will agree that it hasn't, but enough to say that as eloquent as your first entry into our dialectic is, I think there's a bit more one can say appreciatively about the text.
Sure. Well, let me come on to the questions about vagueness, and then about the extent to which we can be charitable about the vision that's espoused in the Constitution. And we're getting into it. We're getting into it now. I think we might need 3 hours actually listening
I
to
suspect
this.
so. But I'm having fun. I clearly missed
yeah, no,
law.
Absolutely. This is exactly what I've been yearning after, like in the public debate, and also wishing to learn more about. But firstly, let me start with vagueness. So let me distinguish between different sections of the values espoused in the Constitution. Recall, I think we effectively agreed that you have the preamble, whose legal effect is virtually nil, but it's still important to narrate the purpose of the Constitution. You have the founding provisions, and then you have the Bill of Rights. Now, my charge of vagueness is directed mainly at the preamble, which is designed to narrate our history. And I'll concede all the other points about vagueness in the founding provisions, which relate to this trinity of values of dignity, equality, and freedom. If you say dignity, equality, and freedom, of course, they're going to be essentially contestable concepts. They're going to be vague, and you're going to need to interpret them. And even some of the rights in the Bill of Rights are, of course, also going to be contestable. And in fact, exactly how you balance them is going to be vague and left open to future generations to distill and debate. My problem of vagueness is a deeper one related to the preamble, and firstly, the way that it narrates South Africa's history. And I think here the vagueness goes beyond the traditional vagueness of any legal text. I think it's almost an ultra vagueness. And so when the Constitution opens with the phrase that we, the people of South Africa, recognize the injustices of our past, I think that's ultra vague. That's not just saying dignity, equality, and freedom. Which injustices of which past? We come out of an apartheid past, a colonial past, and it's clear to me that the framers kind of think that, and subsequent jurists think that that's what the past means. But we also have conservative people saying, well, it's not just that past, it's also the past of squabbles between the Dutch and the English and all of that. And so when we talk about the past, I feel that we allied apartheid and colonialism, and therefore the vagueness stretches beyond the bounds of even legal vagueness. And so that for me is a problem. One other piece of vagueness that I think is particularly troublesome to me when I look at the values comes in the founding provisions, and this is this idea of non-racialism. And so we have dignity, equality, and freedom, which I think is the first kind of part of the founding provisions, and then the second one is non-racialism and non-sexism. Non-racialism is even more vague than non-sexism, because one would think if it was non-sexism, you would say non-racism. But we've got non-racialism. And that term, I think we have seen as life has unfolded in South African society, is so vague that on the one hand, the DA professes to be non-racial, and on the other hand, the PAC claims the term non-racialism. And here again, I would have preferred a much bolder framing, around racial justice, or at the very least non-racism. So that for me is the vagueness question. The deeper question is when we look at the panoply of values that are presented in the document, right from preamble to the end of Bill of Rights. I'm certainly not arguing that they don't represent an advance and that they aren't, in some ways, very progressive. In fact, I think many of them are. So, you spoke about socioeconomic rights. I certainly concede the point that, I think it's Section 24 on environment, virtually unheard of. Even some of the socioeconomic rights, in terms of access to goods, are unusual in constitutions, not unheard of. Mm-hmm. However, sometimes I think that there's a bit too much self-congratulation going on, and I think that we applaud the socioeconomic rights, which at the end of the day, let's face it, guarantee life's basic necessities, right? We're talking food, water, housing, maybe social security is a little beyond that. But what we don't find in the Constitution, and this is, I think, a key question, what's not there, is a much more tangible economic justice language, which not only guarantees people basic necessities, but says something about the economic injustice and the future economic justice that needs to prevail in a society. Now, I'll stop there because there may be various problems with trying to frame such a clause, but to me, merely guaranteeing life's basic necessities, progressive as it seems in comparison to an 18th century constitution, does not take us far enough in securing the kind of economic racial justice, economic even gender justice, that I think is necessary in a society of our levels of injustice.
Look, Sizwe, I think we're soon going to come to the second question, which is exciting, because I think it naturally raises its own head at this stage of the conversation. Yeah. But let me just, for completeness sake, engage what you've just said now. You can have the last say, and then let's deliberately deal with the second question that we have framed. A couple of things you've said I not only agree with, but would want to add to it. Just as the Truth and Reconciliation Commission inadequately, if at all, some might argue, addressed economic justice as a key element of colonialism and racism and apartheid. Similarly, the Constitution cannot be said to be strong on the question of economic justice. You might use even stronger language than I have, but we agree on that. Socioeconomic rights are one species of economic justice. It is not coextensive with an entire depiction of what economic justice is and what it looks like. There we are fully in agreement. There is, and this is not a theoretical justification, but it is to say that from a point of view of the history of constitutional lawmaking, we should appreciate, even if we lament how it ended, the debate that played out at CODESA around whether to have the text that we ended up with, or to have a bolder description of a list of things that every citizen is entitled to. The Constitution doesn't say this is the definition of a school. It took litigation to get the Department of Basic Education to agree on a legal definition of what a school is, which then makes it easier for civil society to hold them accountable, because we now have a definition of what a school is. That's not in the Constitution. The big debate, and even this I'm glossing over for the sake of time, but for the average viewer and listener, hopefully this is interesting and new nevertheless, was, do you depict literally what is called a minimum core of each of those rights, where you say the right to water entails the right to 10 glasses per day. Every citizen must get so many units of electricity. Or do you deliberately have enough language there to be able to hold the state accountable, but you are not so prescriptive that you actually dictate quantities? Hence we say you are entitled legally to housing subject to the progressive realization of that right, which was intended to mean we want to get the separation of powers right. It is the government that must come up with policies based on a mandate they've sold to the citizenry successfully in the elections, and then come up with a specific policy that is unique to the vision that they had sold to the public, and the public gave them political legitimacy to enact those policies. But we never want to trust government again, because the apartheid era showed us what happens if there's parliamentary sovereignty. So how do you balance skepticism about the state with not interfering with the political arena needing to have some autonomy away from the judiciary? One way to do it, and we can quibble whether it was the right way to do it, but this was the intention behind the design, was to say there's enough in the text for Zaki Ahmad and his friends to be able to go and hold Manto Shabalala Msimang accountable, but not so much that you interfere with the sui generis operations of the political arena. And that's how you ended up there, rather than what we can now with hindsight say, depending on your philosophical position, might have been a preferential way of doing it, and to say, not only are we going to be bolder in our demands, we're actually even going to specify it, and we're prepared to be accused of trampling on separation of powers if that means getting closer to an ideal and a just South Africa. So that's what you are agitating for as I read you, and it's not a bad thing, so I'm not saying that as a reductio of your argument, but I think that's the spirit of what you're saying. And there were some people who wrote into that. And on the other hand, funny enough, out of historical interest, there were serious analysts like Stephen Friedman who thought that what was put on the table as the sort of compromise was itself too much of an incursion into the autonomy of the state, who thought we shouldn't even have legally enforceable second and third generation rights. So as much as you are critiquing this as too low a bar of what the state must do, this was such a controversial question that some people thought we were already going too far to even contemplate having it in the Constitution. And so there's a multiplicity of viewpoints that scholars, commentators, political parties had. And contingently, this is how it ended up in terms of the negotiations that took place. With the benefit of hindsight, should we have demanded more? Well, I think it takes us into the second question that you can kick us off with. I'm not convinced it would have made a difference.
Well, what you've said, I think, leads us to a really interesting place, which is that this constitution may well have been the appropriate, or at least the only possible set of values underpinning South Africa in 1994. And because of the balance of forces at that time, especially the fact that the ANC wasn't even in government yet, I can quite understand, unlike many critics of the Constitution, how we arrived at this text. And I think the historical backdrop is important for us, firstly, to understand that this is, to some extent, the outcome of a compromise. Now, of course, both sides of that compromise have claimed victory in that compromise, which shows you how much of a compromise it is. The ANC people who claim to have drafted the Constitution say nobody gave a thing, we outmaneuvered everyone, and vice versa. And I worry that we have people who have skin in the game in these debates, because we still have the people who actually drafted these things participating in the debates. And I'm like, well, I'm sorry to say, but you might be a little biased having actually written some of these sections or participated. But the deeper question for me, and I suppose this is a segue between our first question and our second, is it the right document for South Africa today? So that with the benefit of 3 decades of hindsight, which the framers didn't have at that time, is this still the right way to frame the economic or lack thereof clauses in the Constitution? And so now, as we stand today, can we still not go any further? Or is there further space to experiment, for goodness sake? And a part of my problem with the way that the debate has unfolded is that if we already assume that the Constitution strikes the perfect balance and is the perfect way, or is the optimal way of striking the balances in our body politic, then we concede that there's no possible better present or future text. And so I'm interested now in whether we could change that and say, well, look, back then we thought that we were being super progressive by guaranteeing water to people, which is, whether it's a guarantee is controversial. But look, we figured out that 3 decades later, even if we do guarantee water, it still doesn't change the structural injustices at the heart of our economy. Maybe we need to go even further, and like the Indian constitution or like the Brazilian constitution, we actually need to say that distributions, grotesque, obviously this wouldn't be a provision, we would legalize, we'll tell our legal friends to write a legal one, but grotesque distributions of unequal distributions of wealth are just so bad that we actually constitutionally want to give the leeway for the state to never allow that kind of situation. And so for me, whether the Constitution was right for the 1994 is a separate question to whether it's right for 2022, and that's the more interesting question for me. And so leading into this question about the effect of the Constitution, and whether the Constitution is to blame, or to what extent the Constitution has a causal effect on the injustices that we all identify, my answer is a qualified yes. And here I need to point out what I think is an inconsistency on the part of constitutional optimists, as it were. Because on the one hand, we hear that the Constitution, according to the Minister of Justice, is responsible for all of our gains since 1994. This is Ronald Lamola writing in response to Minister Lindiwe Sisulu. Mm-hmm. But on the other hand, we hear that it's responsible for none of our failures. All of that is just government failing to execute. So which is it? If the Constitution is powerful enough to found our government and to represent these tremendous gains since 1994, then how come its failures and its ineptitudes are not responsible for the injustices, which, by the way, mirror the constitutional text's blind spots, in my view? We have a problem of racial justice. We have a problem of economic inequality. We have this problem of economic justice, on which the Constitution is silent, and yet apparently the Constitution has nothing to do with that. It's all
so
it's
let me
all
challenge you this, right, and ask you for a concrete example, or offer you one.
Yeah.
Inequality in this country is a massive problem. Or you can pick a better example if it's more helpful to explaining your position.
Yeah.
Give us an example of an obvious, massive South African problem that is sustained, if not sponsored, by the constitutional text.
Well, the problem of racial injustice, right? On the one hand, we have a constitution that says non-racialism is a founding value, and fails to use the word apartheid as what we're actually trying to uproot. And on the other hand, we have this problem of racial injustice in South Africa. And so it seems to me that what can a constitution do? Well, it can't take money out of people's bank accounts and put them in other people's bank accounts. On that, I'm sure we all agree. But what it can do is it can open the legal and even executive room through the way that it prohibits things or allows things to, to be done, 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 to not frustrate certain governmental action or societal action towards racial justice. Now, my problem with the absence of racial justice, official or explicit racial justice language in the Constitution, is that it's still so vague as to equivocate between this unhelpful non-racialism, which we find in conservative circles, and progressive racial justice. I'm not sure that the Constitution knows which is which, and I think that has something to do, not everything to do. I don't want to be misread to be saying that the state has secured, because the state could have done more, and is probably more to blame. But my point is not that it's one or the other. My point is that what we need is both. We need an effective state and constitutional enablement at the same time in order to tackle this kind of problem.
So let me say a couple of things. Firstly, like you, I don't like the word and the concept to the extent that the concept is clear, and I'm not sure it is, non-racialism. I think if you're genuinely committed to racial justice, you should frame it as a commitment to anti-racism. I prefer that language for reasons I've said elsewhere, but it's worth reiterating it a million times until it becomes trite. Anti is a more active bit of language. Non doesn't suggest that I am using my energies deliberately, intentionally to oppose something. Racism
Sure. Yeah.
is a fundamental oppressive system. Racialism, on some definitions, may simply, for example, refer to phenotype. And I'd rather know that if you are in the business of racial justice, that you are committed to putting it all together, actively and intentionally taking steps in community with others to eliminate the oppressive system of racism, its most obvious manifestation being white supremacy. The language of non-racialism, for me, doesn't capture that. South Africans who are older than both you and me don't like our critique, which is perhaps one we should have on your platform or mine on another occasion. There are many people who share broadly your politics and mine, but who think that we don't pay sufficient attention to the historical movements, for example, mass democratic movement in the 80s, who had a robust, clear understanding of non-racialism, and that we shouldn't be annoyed by the misappropriation of the DA. I get that, but like you, I think it's worth asking, even if something served us well in the 80s, can we recognize that perhaps a new language is needed, even if some of the old politics is retained, because the old language is misappropriated in ways that you must pay attention to and not romanticize more accurate usage in the past that is gone. I am on board with that.
Yeah.
There, you and I are totally on the same wavelength. Where we part ways, you know my view because we're friends, but for the public to get a sense of where you and I part ways, and my view is very simple here. The state and other actors like business or powerful individuals who've got privilege and power have the burden to bring about a just South Africa. A text is just words. What you've reminded me of, which is kind of obvious, but in a deep sense there's a lot to be said for this obviousness, is that if I overstate my position, then I'm implying that the text doesn't matter at all. And you are right that the text does matter. So what the text says is critically important. Otherwise, we may as well not have a text. That you've convinced me of. What I'm less persuaded what I'm less persuaded by is that if we changed the text to be a bit more specific in the preamble, that we are trying to undo the legacy of colonialism and apartheid, that we are fighting for racial justice, that we are anti-patriarchy, anti-racism, I can't see how that will make Cyril Ramaphosa less useless tomorrow.
Well, I think we probably agree that it will take a miracle for that to happen. And look, this is where I feel we we're coming to the limits of what, you know, of this debate, because I also don't know. And the question, you know, really is exactly how much does changing a text, or even the text, you know, make an impact on the society? And my preliminary view on this is that constitutions do play a causal role in societies, but not a kind of proximate causal role. So as I say, they determine the design of the gun, but they don't pull the trigger, as it were. And so sometimes it can be hard to see that causal role because it's never immediate and it's never obvious. But I think constitutions do play an important causal role in what they allow for and what they disallow. So when the Constitution says everyone has the right to life, full stop, that does have a causal role in political life, and, you know, prevents the state from being able to pursue a criminal punishment system which includes the death penalty. Now, the state does not go and hold the Minister of Justice's hand as he's trying to make policy, but a very clear link can be drawn between guaranteeing the right to life and subsequent penal policy. And in the same way, then, I believe that if the Constitution were to, let's say, have an economic justice clause in the Bill of Rights, or if it were to have a land clause that was separate from a property clause, or if it were to say that we are about racial justice, I think that would have downstream effects, not only in constitutional jurisprudence, but it would have downstream effects in policy making. And it would limit the space for conservative elements to say, well, non-racialism, well, what we really mean is that white men need to be, you know, treated the same in all contexts as black women. But once again, to be fair, even if we did change the text to allow for that more permissive environment, as it were, not a jot would change without other things happening. And that's the weird thing about constitutions. They allow you to make a change, but they don't do anything beyond that. And so if we really were to, I mean,
and I guess in a weird kind of way, we're reaching a sort of a consensus. But before I try and articulate that consensus, which might be a nice way to end the conversation, let me say a dramatic irony that I just observed about your position. Ironically enough, your position requires you to be a constitutional optimist. You have to be,
and yours requires you to be a pessimist.
Yes, it requires optimism about the causal effect of the constitutional text on the behavior of politicians and civil servants. Which is kind of interesting, because a lot of your critique
how did that happen?
Okay,
I withdraw, Jay.
I think that's kind of interesting, but the reason why I still think we kind of meeting each other halfway, not for the sake of gumbayasm, but I think out of political honesty, is that the text matters, and it of course is the case that Makwanyane happened because the right to life, dignity in particular as a foundational value, and some of the other rights in the Bill of Rights and foundational values were crucial to making sure that we ended that. The same with the Williams case, corporal punishment being ended. The constitutional text had a causal effect on the state no longer being capricious. On the other hand, I think about people who are less legalistic in their analyses of social and political dynamics, like my good friend Richard Pithouse, who will remind us that this remains a liberal state. And, you know, I'm a liberal, but I'll use liberal there in the bad way that liberalism is critiqued by some on the left. And notwithstanding the examples that you've given, including the death penalty, the same state brought us Marikana. The same state cracks down on Abishlali in eThekwini. This same state has got soldiers that go into the yards of citizens and kill poor people. So we've got a violent South African state that is intrinsically violent with awkward continuities with the apartheid state, despite the constitutional text that I defended so lyrically at the beginning of our constitution. So on the one hand, I want to honor the examples that I put on the table, but I also want to contradict myself a little bit by saying, if we pay more attention to those analysts and scholars that are squarely empirical and brutally empirical in their observation of the state, then we've got to be honest that the question about the quality of the state, the quality of the bureaucracy, the values of the politicians that are at the helm of the state, those questions for me, Sizwe, is why, from a political sociology point of view, you and I disagree on the Constitution. It's not so much that I love the Constitution with the same kind of fetishism that lawyers narrowly educated in law do. My defense of the Constitution, now that I think about it, is actually based on skepticism of the Constitution. And it's based on a debate we're not having that is the elephant in this discussion, which is a debate around statehood. What makes or break a state and a bureaucracy and civil servants and the service they provide to citizens? And I think you would agree with me that if we had another hour to spare, which we don't, the Constitution would just be one out of about 5 or 10 contributing factors that a more complete analysis of statehood requires us to deep dive into. So that even if we had the constitutional text that you think ideally we should have, it would make a difference. The text matters. But if you score really low on all of the other contributing factors, then you might still end up with an ANC government that is uncomfortably echoing elements of P.W. Botha's era.
And I think I've
got nothing more to say beyond that. You can have the final say.
Yeah, no, absolutely. And I think it's a fascinating irony that we've arrived at, but I think it's also useful for the public debate more widely to realize that positions which seem diametrically opposed are actually closer together when we disentangle them, and we realize that, those of us who are optimists about the Constitution are actually not so sure about this whole thing when we look at it.
Yes.
And those of us who are pessimists are like, whoa, hold on, don't touch my Constitution. You know,
there is something I do want to add.
For me,
I thought you were having a grammatical pause. While you have the grammatical pause, I'm not going to say it now, but I do have something I do want to end with, which is this widening of our conversation in the last 10 minutes. Should it be relevant to picking a Chief Justice? Just remind me that we should touch on that.
That's very true, actually. Oh my goodness, this conversation is going in all the right directions. For me, you know, what I just wanted to say to wrap up the Constitution, then to throw forward to the Chief Justice and what the role of the Chief Justice is in all of this, is we often talk about the Constitution as a living document, and there's a great deal of rhetoric about how it's a living document, and I'm afraid it's dead as a doornail, if you ask me. Especially these values questions, right? Yes, it can be a living document when we change the Superior Courts Act and the SCA does something different and all of that. But we have not yet changed a single thing about the values that we agreed on in 1994. And so for me, the interesting project is how do we really make the Constitution live? I'm not interested in just totally abolishing it and starting from scratch, but I'm also not interested in just keeping it the same for time immemorial. And it feels to me like we're at a juncture in our society and in our country where it's time to try something different, and we might get our fingers burned, but can we make this document live rather than just pretending that it's alive when we've never actually tested its vitality? Having said that, just on the Chief Justice, which you raised, which is a key question. One of the interesting things, and maybe we can end here, which we have been saying for the last 20 minutes, is in the Sisulu debate, which kind of sparked this whole thing off, right? There was this view that, well, she must resign, and there are many reasons why she might have resigned because of what she said, but one of the reasons was, if you don't like the Constitution, then how can you take an oath to defend the Constitution? And the Sisulu example is a really crude one, but do office bearers, especially the Chief Justice, have to love the Constitution in its current form? And are they allowed to critique the Constitution? And so for me, sometimes it feels like the battle for Chief Justice is a competition for who can praise the Constitution the most. And that's how we define defending, upholding, and respecting the Constitution. Whereas for me, I would like a much more expansive definition, which is that, yes, you understand that the Constitution is this wonderful document that presents an advance, but you have problems with it. And these are, like, I'd love to see someone in the JSC interview said, these are my problems with the Constitution. This is actually what I would change because of X, Y, and Z reason. It doesn't mean I hate the Constitution, but I think we've failed here. But I fear that were a candidate to do that, various commentators and observers would say, well, they don't like the Constitution, so they don't deserve to be Chief Justice.
Yeah, that's a huge question. I won't engage it. Just say one or two things. Because I'm creatively exhausted in a really satisfying way from this conversation, and I hope the viewers are, whether they've watched it in 2 or 3 sittings or in one sitting. But I do want to say this. I think your question is interesting. I mean, I sit on scholarship panels, and people from many disciplines come on. Sometimes we will ask a law student, do you have an example of a case that you think the Constitutional Court got wrong? I would love to hear the JSC asking that of the Chief Justice candidates. When do you think the Court got it wrong, for example? From your own body of work, is there a decision you regret jurisprudentially? Because I think that ability to
even the text, where do you think the text gets it wrong?
Yeah, I think that ability to self-examine is crucial to being a good jurist. So I think you're onto something, Sizwe. I wonder whether I'd be comfortable as a citizen, and maybe I would be wrong to be uncomfortable, but I'll sit with this beyond our conversation. But I wonder whether I'd be comfortable with a candidate saying, I don't think constitutional supremacy is a principle that we should have signed up for in 94 and 96. We made a mistake to do so.
Yeah, sure.
I think there's some minimum things that I want the Chief Justice to commit to. The main way through which they must express views that they have about the text is in the adjudication of the Constitution. But I do think we should make space for, philosophically, a wider range of views about the Constitution than this business of effectively looking for who can say the nicest things about the Constitution during their interview. But what I would say lastly, what doesn't help us, with few exceptions, there are way too many members of the JSC who do not think carefully enough about what is the function of my line of questioning, what question can best help me and the country to know whether this person is jurisprudentially the right kind of person, and in terms of the values that they have and carry through their work, are they the right kind of person? For way too many JSC members, it's an opportunity to reinforce their narrow partisan interests, which is really unfortunate. One of the few times when I've heard really interesting constitutional law and jurisprudential questions being asked was when Dennis Davis many years ago applied and was shortlisted, and I went to the session that was held back then in Kliptown. But for the most part, it's rare to watch, even over the next couple of days, and I'd love to be wrong, to watch an interview where it's fundamentally about the kind of issues that you've outlined. But let's see how it goes. I'd love to hear questions being asked about the vision of the Constitution, about how you narrow the gap between constitutional text and empirical reality, and then specific questions that tease out the constitutional humility of the judges to see whether they can actually critique themselves and critique the bench.
Well, Eusebius, it's been a joy to have this conversation. I hope viewers and listeners have found it useful, and thanks for this chat.
Thank you, Sizwe. I look forward to another installment, but I think I'm very full for today.
Definitely.
In a really awesome way. Thanks for having me on your platform as well.
Pleasure's mine.